The Pentagon is simultaneously suing, contracting with, and deploying AI from the same company. Anthropic's Claude is generating target proposals on classified networks, while the DoD has blacklisted the company as a supply chain risk. Meanwhile, the Agentic coding wars just got a SpaceX-sized price tag, and the entire AI security standards community is stuck in a glossary fight that's leaving defenders without a common language. From the team at the Synthetic Daily, it's Wednesday, April 29th, 2026. Good to have you with us.
We went through about 9 posts, articles, and threads across LinkedIn, Substack, and YouTube over the past week to dive deeper into the world of AI in government and defense.
This next one surprised me. Here's a story that should make your head spin. Right now, today, Anthropic's Claude model is deployed on classified Pentagon networks through Palantir's Maven Smart system. According to the Washington Post, it's generating proposed targets in the Iran campaign. At the same time, the Department of Defense has officially designated Anthropic a supply chain risk, a label normally reserved for companies like Huawei or Kaspersky, entities the government considers potential adversaries.
How did we get here? The DoD's January 2026 AI strategy. And yes, they're now calling it the Department of War, mandated that all AI models used by the military must be available for, quote, any lawful use, with zero usage policy constraints. Anthropic said no. They wanted assurances their technology wouldn't be used for fully autonomous weapons or domestic mass surveillance. The Pentagon responded by branding them a supply chain risk, which effectively forces every defense contractor to certify they don't use Claude.
A federal judge in California, Judge Rita Lynn, called this Orwellian. She wrote that nothing in the governing statute supports the notion that an American company can be branded a potential adversary for expressing disagreement with the government. She blocked the designation. But then a D.C. appeals court denied Anthropic's emergency stay, leaving the blacklist in place while litigation continues. So we have split courts, an active deployment on classified networks, a formal blacklist, and a company simultaneously inside and outside the Pentagon's good graces.
What's the legal mechanism making this possible? Other transaction agreements, OTAs. These sit outside the federal acquisition regulation entirely. The guardrails are whatever the parties negotiate. As Lawfare detailed in a March analysis, when you do military AI policy by contract rather than by regulation, you get exactly this kind of incoherence. The same model approved through one contracting vehicle and banned through another.
One more thing before we wrap the main stories. Let's put some dollar figures on this shift. The Pentagon's Chief Digital and AI Office, the CDAO, committed nearly $800 million across contracts with 4 companies: Anthropic, Google, OpenAI, and Elon Musk's xAI. Each contract has a $200 million ceiling. The stated goal is developing agentic AI workflows across military mission areas.
But the number that really matters isn't 800 million. It's 30 days. The DoD's AI strategy mandates that any new frontier model must be deployable on Pentagon systems within 30 days of public release. Think about what that means. When OpenAI or Google ships a new model, the military wants it running on classification-level networks within a month. That's a procurement timeline that would have been unthinkable 2 years ago.
Pentagon CTO Emil Michael laid out the vision publicly in December. AI capabilities delivered to potentially all 3 million Pentagon users across every classification level. He framed rapid deployment as the antidote to what he called years of procurement and ethics bottlenecks. The word ethics doing a lot of work there. It's a direct shot at the previous administration's guardrails.
Meanwhile, xAI announced its products are now available on the GSA schedule, which means any federal department, agency, or office can purchase them without a special contracting vehicle. And Palantir's Maven Smart system, the platform actually running these models in theater, just got designated an official program of record. That's bureaucratic language for permanent. It's no longer a pilot or an experiment. It's infrastructure.
Let me bring up something related. Rock Lambros posted about a scene in Washington this week that perfectly captures a different kind of dysfunction. NIST, OWASP, SANS Institute, the Cloud Security Alliance, CISA, the Coalition for Secure AI, and about half a dozen other standards bodies were all in the same room. The challenge they're facing sounds almost comically basic. They can't agree on what to call things.
You know what stood out to me? The same AI security risk gets a different name depending on whether you're reading BIML 78, ISO 27090, the European Standard PREN 18282, ITUSG 17, the OWASP AI Exchange, the LLM Top 10, or the new Agentic Top 10. Each document represents real, useful work by smart people. But together, as Lambros put it, they're a glossary fight. And security teams can't operate when the words don't match.
This isn't an academic problem. When a CISO at a defense contractor is trying to assess whether their AI system meets DoD requirements, they're potentially cross-referencing 6 or 7 frameworks that describe the same vulnerability differently. Prompt injection in one document is input manipulation in another, is adversarial misuse in a third. The risk is identical. The compliance overhead triples.
What makes this particularly urgent right now is the FY 2026 NDAA Section 1533, which tasks the Secretary of Defense with establishing a cross-functional team for AI model assessment by June 2026. That team needs an assessment framework. If the underlying vocabulary is fragmented, the framework either picks winners among competing standards, alienating everyone else, or produces yet another layer of terminology that security practitioners have to learn. The people in that DC room know this. They just haven't solved it yet.
Chris Hughes published a piece this week with a title that says it all. The NVD just threw in the towel. The National Vulnerability Database, NIST's authoritative source for vulnerability intelligence that underpins basically every enterprise security scanning tool, has effectively acknowledged it cannot keep pace with modern disclosure volumes.
That's a great point. Hughes has been sounding this alarm for over a year. The NVD was underfunded, understaffed, relying on legacy manual processes, and operating on a model designed for a world where maybe a few thousand vulnerabilities got disclosed annually. We're way past that now. The enrichment pipeline, where raw CV entries get the metadata that makes them actually useful for prioritization, has been breaking down. The backlog keeps growing.
So what fills the void? That's the billion-dollar question for every security team that currently relies on NVD data flowing into their vulnerability management tools. Hughes and others like Josh Bressers and Dan Loring have been discussing alternatives, commercial feeds, community-driven enrichment, distributed models. But here's the thing that connects this to the bigger AI in government story. The Pentagon is deploying AI systems at unprecedented speed while the fundamental infrastructure for tracking vulnerabilities in software is crumbling. You've got the CDAO demanding 30-day deployment timelines for frontier models, and the database that's supposed to tell you whether those systems have known flaws can't keep up with disclosures from 3 years ago.
I want to add something to that. The NVD collapse isn't just a cybersecurity story. It's a governance story. When you move this fast on AI deployment, military or otherwise, and your vulnerability tracking infrastructure is failing, you're flying with instruments that lag reality by months.
Now, shifting gears a bit, Tomasz Tungus dropped a bombshell analysis of the SpaceX-Cursor partnership announced this week. A $10 billion collaboration with a $60 billion acquisition option later this year. Those numbers are staggering for a coding tool company, but Tungus argues they make sense when you understand the 3-layer stack that wins in agentic coding.
Layer 1 is compute. Layer 2 is models. Layer 3 is distribution. Anthropic, OpenAI, and Google each own and operate across all 3 layers. Cursor, the AI native code editor that's been eating VS Code's lunch, owns distribution to developers but depends on external models and compute. SpaceX, meanwhile, is building out compute infrastructure through Starlink's edge network and has an obvious need for AI-assisted engineering at massive scale.
The $60 billion acquisition option is essentially a call option on vertical integration. If Cursor proves it can be the distribution layer for agentic coding at SpaceX's scale, think autonomous code generation, testing, and deployment across rocket firmware, satellite constellation software, and Starlink networking, then $60 billion is the price of owning that entire developer workflow.
Exactly. And on a related note, this maps directly onto the defense AI story. The Pentagon's agentic AI ambitions need coding tools too. When the CDO talks about deploying AI within 30 days of release, someone has to write the integration code, the security wrappers, the deployment pipelines. If agentic coding tools can do that autonomously, or with minimal human oversight, you've compressed not just model deployment, but the entire software engineering cycle around it. The SpaceX-Cursor deal isn't just about developer productivity. It's a bet that the company controlling the agentic coding layer controls how fast AI gets built into everything else.
So let's start with the big story. One more piece of the puzzle that ties this all together. In December 2025, President Trump issued an executive order directing a whole-of-government effort to preempt state AI laws. The Attorney General was given 30 days to establish an AI litigation task force whose sole job is to challenge state laws that conflict with federal AI policy.
Right, and why does this matter for the defense and enterprise audience? Because state AI laws were becoming a patchwork nightmare for any company trying to deploy AI at scale. If you're a defense contractor operating in 40 states, and California has one set of AI disclosure requirements, Illinois has another, and Texas has a third, your compliance costs explode. The executive order essentially says, we're going to have one national framework, and we'll use federal funding as leverage to force compliance.
The specific mechanism is conditioning BEAD broadband funding on state compliance with a national policy. That's a carrot-and-stick approach borrowed from how the federal government has historically enforced highway speed limits or drinking age laws, attach conditions to money states want.
That tracks with what we've been seeing. For AI companies selling to the government, this is clarifying. One set of rules instead of 50. For civil liberties advocates, it's alarming. State laws often provided stronger protections than federal frameworks. But for the Pentagon's 30-day deployment ambition, it's enabling. You can't move that fast if every base in every state is subject to different AI governance requirements. The preemption play is the regulatory ground clearing that makes the speed possible.
All right, let's zoom out and talk about the bigger picture. What are the main themes running through everything we covered today? The first big theme is procurement as policy instrument. The shift from regulation-based to contract-based AI governance means that contracting officers and OT agreements, not legislators or ethics boards, are now making the substantive decisions about what AI can and cannot do in national security contexts.
Next, speed versus coherence. Every institution in this week's stories, the Pentagon standards bodies, the NVD coding tool companies, is discovering that optimizing for deployment velocity creates governance debt that compounds faster than anyone expected.
Next, vertical integration race. The SpaceX-Cursor deal and the Pentagon's multi-vendor contracting strategy both reveal the same insight. Whoever controls all three layers of the AI stack, compute, models, and distribution, sets the terms for everyone else.
And the last one, vocabulary as a bottleneck. From AI security standards fragmentation to the legal ambiguity of any lawful use, the inability to agree on definitions is proving as constraining as any technical limitation. So if you're going to take away a few things from today's episode, here's what I'd remember.
Number 1. The Pentagon has created a legal structure where it can simultaneously deploy, blacklist, and sue over the same AI model. And that incoherence is a feature of contract-based governance and a bug.
Number 2. If you're building AI security programs today, bet on convergence. The vocabulary fragmentation across NIST, OWASP ISO, and half a dozen other bodies will collapse into a smaller set of standards within 18 months because the DoD assessment framework due in June 2026 will force it.
Number 3. The 30-day model deployment mandate isn't just a Pentagon procurement quirk. It's redefining what production-ready means for every AI company that wants government revenue.
And finally, state AI law preemption plus NVD collapse means the safety infrastructure is being dismantled faster than it's being replaced. The gap between deployment speed and governance capacity is widening, not narrowing.
That's the Synthetic Daily for today. All the sources and links are on the website if you want to dig deeper.
Thanks for listening. See you tomorrow.
Everybody dancing together.